A Supreme Court decision just dropped that most people are fundamentally misunderstanding, and if you repeat the wrong take online, or worse, if you act on bad legal advice, it could cost you your rights, your property, and your freedom. Quick question before we continue. Are you subscribed? Because what I'm about to reveal about this 8-1 Supreme Court decision could be the difference between keeping your freedoms and losing them without a fight. Hit that button now. Alright, let's talk about the headline exploding across every platform right now. Breaking Supreme Court 8-1 decision just changed both First and Second Amendment rights. Here's what you need to know. There is a real 8-1 Supreme Court decision. It does involve the Second Amendment. And there is a massive First Amendment angle that connects to this story in ways most people aren't seeing. But the way it's being reported is creating dangerous confusion. And that confusion could destroy your freedom. So in this video, I'm going to do 3 things for you. First, I'll break down the actual 8-1 decision, what it says and what it absolutely does not say. Second, I'll show you how the First Amendment fits into this picture and why it matters even if you've never thought about free speech and gun rights together. Third, I'll give you real-world scenarios so you know exactly what to do next, especially if you post online, run a business, or just want to protect yourself legally. The case is called United States versus Rahimi. Here's the core question the Supreme Court had to answer. Can the federal government temporarily prohibit someone from possessing firearms if that person is under a domestic violence restraining order and a judge has determined they pose a credible threat to another person's physical safety? The Supreme Court said yes. That's the bottom line in plain English. If a court has made a specific finding that you are a credible threat to someone's safety, the government can disarm you temporarily while that order is in effect, and that does not violate the Second Amendment. Now here's where it gets interesting. Notice what the court did not say. They did not say the Second Amendment is meaningless. They did not say anyone accused of anything automatically loses gun rights. They did not say states can strip firearms from people without due process just because they feel like it. This decision is about a very specific kind of court order with very specific legal findings attached to it. That detail is everything, because right now, people online are acting like the Supreme Court just gave blanket approval to gun confiscation, and that is not what happened here. Now, let me explain why this case matters beyond just the restraining order issue. This case also involves Bruin. If you follow gun law even casually, you know about Bruin. That's the landmark Supreme Court case that told courts they must judge gun laws using history and tradition, not modern balancing tests where judges weigh rights against safety like they're on a scale. After Bruin, lower courts started fighting. Some judges began demanding that the government find an exact replica of a law from the 1700s before they'd uphold any modern gun regulation, like a historical twin, a perfect match. And the Supreme Court in Rahimi basically said stop doing that. They said the Second Amendment is not a law trapped in amber. In normal words, that means the Constitution is not frozen like a fossil. You don't need a perfect historical twin. You need a historical analog. Analog just means similar in the ways that matter. The court explained that the key question is the why and the how. Why does this law exist? What problem is it solving? And how does it restrict the right? How broad is it? How long does it last? How heavy is the burden? That's the new battleground. Now let's make this real with a story, because stories are how you actually remember legal concepts. Imagine a guy named David. David is not a criminal. He's not a felon. He owns guns legally. He has a concealed carry permit. He's just going through a brutal divorce. His ex files for a protective order. David thinks this is just family court drama. It's civil, not criminal. It's just paperwork. It'll go away. That is the mistake. Because if that order contains certain findings, and especially if it includes language about threats or danger, David can suddenly be committing a federal felony just by having a firearm in his home while the order is active. And that's why you cannot treat restraining orders like they're just emotional noise or temporary inconvenience. Temporary can still mean handcuffs, temporary can still mean federal charges, temporary can still mean you lose your gun rights permanently. Now here's the question everyone immediately asks. Okay, but how can the court say this and still claim we have a right to keep and bear arms? Here's the simple answer. Even in the biggest pro-gun Supreme Court cases, the court has always said the right is not unlimited. Not unlimited does not mean weak. It means there have always been some restrictions. The Rahimi majority explained that historically, American law has included ways to prevent people who pose a genuine threat of violence from accessing weapons. They pointed to older laws designed to prevent armed terror and punish people who threatened others with weapons. In plain English, the court said if you are a proven threat, society has always had tools to temporarily disarm you, and this law fits that tradition. Now this is the part that shocked a lot of observers. Rahimi was 8-1. That means it wasn't a narrow 5-4 split. It was an overwhelming majority. Only one justice dissented. So if you were expecting the court to divide cleanly along ideological lines, this case didn't do that. Here's a detail most people are missing. Rahimi was what's called a facial challenge. In normal language, that means he wasn't arguing this law is unconstitutional as applied to me. He was arguing this law is always unconstitutional no matter what, in every situation. That is the hardest kind of challenge to win, because to succeed he had to prove the law could never be constitutional, not even once. And the court basically said we don't need to decide every possible scenario. The law is clearly valid in cases like yours, where a court found you posed a credible threat. So he lost. And when the court decides a case that way, it matters, because it keeps the ruling narrower than the headlines suggest. Now, let's jump to how the First Amendment enters this story. Here's what you need to understand. The First Amendment angle is not because Rahimi was a First Amendment case. It wasn't. The First Amendment side comes from a different legal battle happening at the Supreme Court level that impacts the gun world in a completely different way. Here's the First Amendment issue in simple terms. The government cannot use its power to secretly pressure private companies into censoring or punishing speech the government doesn't like. That includes gun-related speech. That includes firearms advocacy. That includes organizations the government wants to silence without actually passing a law. Why does this matter to you? Because in real life, the fastest way to destroy a movement or a business is not always to outlaw it. Sometimes it's to cut off the banking, cut off the insurance, cut off the payment processors, cut off the basic infrastructure. And if government officials can hint to regulated companies that they should stop doing business with certain speakers, while waiving the threat of regulatory investigations or enforcement actions in the background, that becomes a backdoor way to kill speech. That's a First Amendment violation. And gun owners need to care about this because the gun debate is not only about firearms, it's also about whether you can talk about firearms, organize around firearms, teach about firearms, and advocate for firearms without being financially destroyed. Most people think I only care about the Second Amendment, but here's the truth. The First Amendment is the engine that protects the Second. If you can't speak, you can't organize. If you can't organize, you can't fund legal challenges. If you can't advocate, you can't push back against bad laws. In a unanimous 9-0 decision earlier this year, the Supreme Court ruled in favor of the National Rifle Association in NRA versus VULO. Justice Sonia Sotomayor wrote that while the government is free to persuade or criticize, it cannot coerce private entities to punish a group for its speech. The court found that a New York financial regulator had allegedly used her power to pressure banks and insurance companies to stop doing business with the NRA. The court said that when the government uses its power to coerce a private company into silencing a specific viewpoint, it is a violation of the First Amendment. This is the collision point. When you hear both amendments changed, the smarter way to think about it is this. The Supreme Court clarified how courts should evaluate gun restrictions under the Second Amendment. And separately, it has reinforced constitutional limits on government pressure campaigns that threaten speech under the First Amendment. Two separate legal lanes, but they collide in the real world every single day. Now let's get into what everyone actually wants to know. What changed for you today? I'm going to give you 5 critical takeaways. First takeaway. Credible threat is not just a legal phrase, it's a trigger. In Rahimi, the court focused heavily on the fact that a judge had found he posed a credible threat to someone's physical safety. So if you ever face a protective order situation, you need to understand what that order actually says. Does it include findings about violence? Does it say you're a credible threat? Does it contain language about danger or physical harm? Those details can determine whether possessing a gun becomes a federal crime. Second takeaway, notice and a hearing matters. One reason the law in Rahimi survived is because it involves a court process. The system is supposed to provide notice and an opportunity to be heard before the restriction takes effect. That doesn't mean the system is perfect. It doesn't mean you're safe if you ignore it. It means you must take it seriously. You must show up, because ignoring a hearing can become the exact thing that destroys your case. Third takeaway, temporary can still ruin your life. People hear temporary disarmament and think it's no big deal. But if you get charged with violating this law, you're not dealing with temporary stress. You're dealing with permanent consequences, criminal record, legal fees, loss of gun rights forever. Even if you win later, the process itself can punish you. That's why you never gamble with court orders. Fourth takeaway, Bruin is still the controlling test, but the court wants it applied correctly. Rahimi does not erase Bruin. It does not replace Bruin. It tells lower courts how to use Bruin the right way, and that matters for every future gun case. Because now a judge can't just say, I didn't find a perfect law from 1791, so this modern law fails. They have to ask, does this modern law match a historical principle in the important ways? That standard can save some gun laws. It can destroy others. Fifth takeaway, the First Amendment matters more than most gun owners realize. If you run a firearms business, if you teach gun safety classes, if you post content online, if you support Second Amendment organizations, you are affected by the free speech side of this fight, because pressure campaigns can come through channels you don't expect. Banks, insurance companies, social media platforms, payment processors. Now, right around now, if you're still watching, I want to hit you with a hard truth. Most gun owners don't lose their rights in some dramatic standoff. They lose rights because of paperwork, because they skipped a court hearing, because they didn't read a form carefully, because they assumed a restraining order wasn't serious, because they made a bad decision while angry. And the law does not care that you're normally a good person. The law cares about what's written down, what's filed, what's ordered, and what you did next. If you're finding this helpful, imagine what you'll learn when I break down the 5 words that can protect you during a police encounter involving your firearm. Subscribe so you don't miss it. Now, let's get more practical. I'm going to walk you through 3 scenarios, and I want you to imagine yourself in each one. Scenario 1, the traffic stop. Imagine you're driving home from the shooting range. You have your firearm properly secured in a locked case. Everything is legal. A cop pulls you over for a broken taillight. You're nervous. You start talking too much. You start explaining things the officer didn't ask about. You start reaching for documents without being told. Here's why this ties into today's topic. Your words are your First Amendment in action. Your firearm is your Second Amendment reality. And the absolute worst thing you can do is panic and create suspicion where none existed. I'm not telling you to argue with police. I'm not telling you to be confrontational. I'm telling you that understanding your rights is not about acting tough. It's about acting smart and staying calm. Scenario 2, the ugly breakup. Imagine you and your partner are splitting up. Things are tense. Emotions are high. One night, you send an angry text message. In your mind, it's just venting. It's not a threat. But the next morning, you get served with paperwork for a protective order hearing. Now, here's the mistake most people make. They think this is just drama. This is emotional. The judge will see through it. But the court is not reading your mind. The court is reading what's on paper. And if an order gets issued that contains findings about threats or danger, it can flip your legal situation instantly. So the smart move is simple. Take it seriously immediately. Get legal counsel. Understand the exact terms of the order. Do not violate it. Do not send just one more message to explain yourself. Do not show up just to talk it out. Because the system doesn't care how you meant it. The system cares what you did. Scenario 3, the silent squeeze. Imagine you run a small gun-related business. You sell accessories. You offer training courses. You make holsters. You teach firearm safety. You're not doing anything illegal. But one day your payment processor suddenly drops you. No explanation. Then your bank starts asking strange questions about your business. Then your insurance company says they won't renew your policy. You ask why. Nobody gives you a real answer. Just vague corporate language. This is the scenario that should terrify everyone watching. Because even without passing a single new gun law, a coordinated pressure campaign can make it nearly impossible to run a lawful business or engage in lawful speech. And that's exactly why the First Amendment side of this story matters just as much as the Second Amendment side. Now let's address the 2 biggest myths I'm seeing in comments and social media posts. Myth number 1. People keep saying, so this means if someone accuses you of something, you automatically lose your guns. No. Accusation is not the standard in Rahimi. The decision talks about a court finding tied to a credible threat determination, and the law includes procedural requirements. That doesn't mean the system can't be abused or manipulated. It means the Supreme Court's reasoning is based on process and judicial findings, not rumors or allegations. Myth number 2. People are saying, so the court just said the government can disarm anyone it labels dangerous. No. In fact, the court did something important here. It did not accept a vague, sloppy label as enough justification. In normal language, the court did not write the government a blank check to slap a dangerous label on anyone and strip their rights. They focused on credible threat findings and a historical tradition of addressing proven threats to safety. Now, I'm going to say something that might frustrate some of you, but it's the truth. If you are a gun owner, you need to be the most careful, boring, procedurally cautious person in the room when conflict arises. Not because you're weak, because you have more to lose. The legal system is not forgiving when firearms are involved. A mistake involving a gun is treated far more seriously than the same behavior without a gun. That's just reality. Quick legal disclaimer, this is educational content, not legal advice. Always consult a qualified attorney for your specific situation. Rahimi is going to be cited in nearly every major Second Amendment case going forward for one key reason, the historical analog framework. Courts have been all over the map since Bruin. Some struck down gun laws aggressively, others upheld them just as aggressively. Some demanded impossibly specific historical examples, others allowed extremely broad comparisons. Rahimi is the Supreme Court's signal that they're watching this chaos, and they're telling lower courts stop demanding perfect historical matches. Use analogy, use principle. That instruction can cut both ways. It can help the government defend certain gun regulations, but it can also help gun rights plaintiffs challenge bad laws, because it forces courts to be honest about the history they're relying on. Let me give you a hypothetical to make this crystal clear. Imagine a state passes a law saying anyone who has ever been treated for anxiety cannot own a firearm. Most people would immediately say that's way too broad. Under the reasoning discussed in Rahimi, a court would have to ask, is this law aimed at a specific proven threat? Or is it just a sweeping category-based rule? Is there an individualized finding? Is it temporary or permanent? Is there due process? How heavy is the burden on the right? That's where these cases are headed. The legal fights are going to center on how narrowly tailored a law is, how much process it provides, and whether it resembles historical tools designed to prevent actual violence versus broad social control. If you only remember one thing from this entire video, remember this. Most people do not lose their constitutional rights in some dramatic shootout with police. They lose rights in boring, quiet moments. A court date they ignored, a form they didn't understand, a text message they shouldn't have sent, a restraining order they assumed would just disappear, a bad decision made out of anger or pride, and the law does not care that you're normally responsible. The law cares about what was written, what was filed, what was ordered, and what you did after. Let me keep this simple and direct. If you have no restraining order or protective order issues in your life, great. Your action step is stay informed, avoid spreading bad headlines, and know your rights. If you are currently under any kind of protective order, your action step is read it word for word, follow it exactly, and immediately speak with an attorney in your state about firearm implications. If someone is threatening to file a protective order against you, your action step is do not send angry messages, do not try to explain yourself directly, do not escalate the situation, and get real legal help immediately, not internet advice. If you run a gun-related business or organization, your action step is understand that free speech protections matter to your survival and watch how these legal developments affect deplatforming and financial pressure campaigns. Here's my final warning, and I'm going to say it as plainly as possible. Do not assume you are safe just because you have never been convicted of a crime. Federal firearms law can apply to people who have never been to jail, never been arrested, and never committed any traditional crime if they are under a qualifying court order and they possess guns anyway. That's why awareness matters. That's why precision matters. That's why you cannot treat constitutional law like internet gossip or viral outrage content. The Supreme Court's 8-1 Rahimi decision says the government can temporarily disarm someone who has been found by a court to pose a credible threat to another person's physical safety, and that does not violate the Second Amendment. It also clarifies that courts must use historical analogs, not demand perfect historical twins, when evaluating gun laws under Bruin, and the First Amendment dimension of this broader legal story is just as critical. The government cannot use backdoor pressure to censor or destroy lawful speech, including speech about firearms and Second Amendment advocacy. If you care about protecting your rights, you need accurate legal information, not clickbait headlines designed to make you angry or afraid. So please subscribe to this channel, because I would much rather you hear the truth here than learn it the hard way in a courtroom or a jail cell. Final disclaimer one more time. I am not your attorney. This is general educational information only. Laws change, facts matter, states have different rules. If you face a real legal issue, talk to a qualified lawyer in your jurisdiction before you do anything. Stay safe, stay informed, and I'll see you in the next one.